Denzale Lee, C371483.
Morning, Your Honor.
I felt like maybe this would be a fist fight instead of a writ argument. You guys got a little bit combatant in these filings. All right. Looks like we are on for a writ. So this is Mr. Hendron's motion. Did you want to be heard further on the written motion?
Your Honor, I'll just stress, so as it relates to the first one with regards to the sufficiency, I think that's been briefed, so there's nothing really further to expand. I'll submit it to Your Honor.
Okay.
Regarding the second one for the attempt to murder, I believe there was some thorough briefing done by the co-defendant's attorney, co-defendant Washington. So I would just simply ask to adopt those arguments, including the reply arguments, knowing that Your Honor's already ruled on both co-defendant Washington and co-defendant Queen denying that request, because I think they were mirrored all together. Like
I think it was all very similar language for at least that one count, yes.
And then with regards, I think 3 and 4 kind of go hand in hand. I know that the state's indicating that there may not be, this court may not be able to hear it based upon the limitations of a pretrial writ. I did look, NRS, what the state does cite to, it does say that the court, quote, or otherwise challenging the court's right or jurisdiction to proceed to trial on the criminal charge. I would think that Your Honor still is able to consider things with respect to the grand jury and whether the grand jury was proper when they returned the true bill in this case. The one concern, and that's highlighted in both 3 and 4, would be the position of implicit bias, any type of bias that may have occurred. Starting with 3 and looking at the response that the state had outlining that perhaps I'm trying to mislead the court, that there's things in there regarding the clerical error. Just so we're clear and it's understood, what I've had and what I've known was looking over, and I have to rely upon the transcripts that I have in front of me, one being the superseding grand jury transcript. What I understood that to be when I kind of broke it down was, during the superseding grand jury hearing, the grand jury was only presented evidence involving Mr. Lee for counts 1 through 5. The grand jury was instructed to only deliberate on counts 1 through 5 as it pertained to Mr. Lee. They return on counts 1 through 5 for Mr. Lee, but then they had instructed the state to prepare an indictment in conformance with the proposed indictment previously submitted to the state. And I got that out of volume 2, the grand jury transcripts at page 168. And it says the grand jury, in instructing the state to prepare the indictment is submitted to them on February 16, 2023, included charges against Mr. Lee that they didn't hear any evidence of. So I'm thinking, and I went back looking at the superseding indictment with regards to the exhibits as well, seeing that there was exhibit 1A and 1B. I tried to think, okay, maybe there was something in 1B that I was missing. And I don't think that's the case, because I then looked at page 160, court's indulgence. I looked at page number 166, lines 1 through 15. And I think what they were doing on the 1B amended superseding indictment, that the proposed amended superseding indictment, was that counts 12 should have not contained Mr. Lee's name. But I have to think then that the proposed superseding indictment reflected that Mr. Lee be charged with counts 23 through 22. There was never anything that was clarified in the second superseding, and other than Mr. Lee not being included on that second superseding proposed, or excuse me, on the second superseding. And then with regards to the third superseding indictment, looking over the transcripts there, it didn't address anything. In other words, I know that the state brought forth that there was a clerical error that was noted on March 6th, and the state indicated in its response that I knew outside the court. The thing that I had known prior to March 6th was speaking with one of the prosecutors on the case is that they were surprised that Mr. Lee was on the superseding indictment, but I was not made aware that it was in fact a clerical error. It was a surprise that, wow, they came back on that. So I just want to make it clear that I didn't have really any guidance until that May 6th date indicating it was a clerical error. And then the next time, then the state goes on March 9th for the third superseding indictment. And again, I didn't see anywhere in those subsequent grand jury transcripts that it was noted that there was this clerical error regarding these proposed superseding indictments. As it relates to, I'll go on to the fourth count then, Your Honor, as well. Again, highlighting my basis why I think Your Honor can consider this for purposes of the pretrial writ. Noting that the state should have canvassed the grand jury to ascertain, based upon any prior media coverage that they may have been exposed to, that they, A, didn't see anything, and if in fact they did, whether that would have any bias on their ability to deliberate and then ultimately returning a bill against any of these co-defendants. And then lastly, as it relates to count 5, Judge, where I wanted to make clear on this. So I understand and I recognize the parallel proceedings that the state can come at, meaning they can come forth in the justice court, outlining a prelim, and they can also pursue by way of a grand jury. However, I think if they elect to choose the parallel prosecutions, that then doesn't mean, okay, so now we're going to indict this case, therefore we're not obligated to provide what's required under statute for the justice court preliminary hearing. And I think that's what you had in this case specifically. And I want to just focus on the first 2 alleged home incidents that take place allegedly on January 11th. That's that's the Prego Street and then the Imperia Street. Those ones were the ones that were charged for the justice court. There was no other matters that were charged at that time. So I recognize that there would be nothing else that the state would be required as it relates to the alleged 3rd home incident and the alleged 4th home incident. But when they are coming and prosecuting those first 2 home incidents, and it's still proceeding, and we're now within that time frame that triggers that they provide certain discovery for purposes of the preliminary hearing, I think that the state has to still abide by those regardless if there is parallel prosecutions. And looking specifically at that statute, NRS 171.1965, it says, but not less than 5 judicial days before a preliminary examination. But right before that, Judge, it even says, or as soon as practical thereafter. And looking under those, what should be provided, looking at, for instance, subsection 1A, would be any written or recorded statements made by a witness or witnesses. I have to think, in order for them to have been prepared to go before the grand jury, that they would have been in possession of some type of statements from some of the individuals that they ultimately have testified before the grand jury. And I believe it was the day before the preliminary hearing was to take place. And then in addition, regarding being in possession, in other words, the state makes this position that they're not in possession of statements, documents, etc. Well, I do think that under Jimenez versus State 112 Nevada 610, that information included, it's not only that's in the actual possession of the state, but constructively as well. So with the fact that this was a joint task with Henderson and Metro, I'm assuming these individuals, law enforcement would have some of these statements, et cetera, that's required under the statute for purposes of the prelim. I get that it's not entitled to for purposes of a grand jury, but when the state's proceeding by parallel prosecutions, that then doesn't automatically shield the state from having to provide these documents and information pursuant to statute under that justice court. And there's no vehicle for the defense, because what ends up happening is the state indicts, and then automatically the process is that justice court case then gets dismissed. So there's never any opportunity for the defense to raise that position that the state failed to comply with its statutory requirements proceeding forth with prelim. And I think that clearly happened here, Judge.
So what's your prejudice on that issue? We're not in a Hubler situation because there was no offer made that you had to consider, and you would need adequate discovery to consider whether it was a reasonable offer, but what's your prejudice?
Well, I think ultimately it could go towards our underlying defense for the case. So there may be specifics that I'm not going to get into. What I would say is it may have assisted, and this is where I understand that the state is saying it can't be used for purposes, they don't have to disclose for purposes of a grand jury, but there may have been very well exculpatory information that was contained in those that then could have been provided to the grand jury, and we've lost the benefit of doing that. Again, understanding that when the state decides to go through parallel prosecutions, they still have to comply with that other requirement. So based on that, it would be what the potential was to provide to the grand jury that Mr. Lee lost the opportunity for.
Well, I mean, now you have it. You have a lot of discovery. What are you putting forth was not presented? If anything. Nothing at this time?
Nothing at this time, Judge,
Okay.
right here.
All right. Dave.
Your Honor, as we've noted, I mean, the pretrial writ is defined by two sets of statute, and it's very limited in the type of issues that can be raised. And so now we're standing here spending 5-10 minutes with defense counsel arguing about discovery obligations in a justice court case in Henderson that doesn't even exist anymore and is not even tied to this case. It's just not an appropriate issue to bring up at this point in time. With regards to the issues he raised in 3 and 4, he tries to kind of shoehorn this language in that the court can consider implicit bias presented to or possibly affecting the grand jury without really defining what that is. The statute says a pretrial writ is to either attack the court's jurisdiction or right to actually hear a case, that's your jurisdiction to hear the case, or to raise sufficiency of the evidence claims. He's injecting this language of implicit bias without, again, defining what that is, possessed by these grand jurors without showing any evidence of any implicit bias by the grand jurors, and asking this court to read into the statute language that just doesn't exist. What that does, in effect, is it opens up the pretrial writ to anything and everything that could possibly be raised. Your Honor already dismissed a writ earlier today because it fell outside the statutorily prescribed deadlines of when a pretrial writ should be raised. It's jurisdictional. The statute is what creates this right to raise it before the court through a writ, and it defines very narrowly what can be raised. So these counts, these challenges raised in grounds 3 through 5 are inappropriate to be raised, and I think his argument just kind of underscores exactly why that shouldn't be raised on a writ. With regards to his issues with count 3, if I could just touch on that briefly, he's arguing argument 3
Sure.
with regards to the grand jury returning on counts 13 through 22, which is what he writes in his writ. He's referencing all these prior transcripts, but you look at the grand jury transcript itself, and we cited to it, and it explicitly states right there, as to Denzale, on this particular date, which was still early in the proceedings, only counts 1 through 5. And yet, even after that, when he was advised that, look, that was a clerical error, he's going to be included later, but he's not included at this point, the grand jury didn't return on that, and that was in court and outside of court, he's still raising that issue today. And he's even saying in his argument, okay, well, I learned on March 6th that it was a clerical error. So then why in April, after knowing it's a clerical error, one that was remedied by the state and then again remedied when we went back to present the additional evidence that he's now bound up on, why is he bringing them up now? If he's already knew back in March that this was a clerical error, he's raising the new argument in April. It's just, to the state's mind, it's disingenuous, and it's an inappropriate issue to be brought up on writ, and it's still not even grounds to dismiss the case. So briefly, if Your Honor has any questions with regards to the two issues that we do think are appropriately raised, which would be the defendant tied to the counts that he's been charged, I'd be happy to address those. Obviously, this is not a case of mere presence. Mere presence would be if Mr. Lee was simply arrested with the co-conspirators without any indication that he was involved in any other crime that we've alleged. We have the defendants, and it's detailed thoroughly in our writ, traveling to the Cancun, going to the Queen's room, changing into clothing that they're then seen wearing to commit 2 home invasions after that. We have evidence from the Queen's Ridge case, tying them all together and putting them all there, with the victim describing their numbers, their race, what they're wearing, all consistent with what Mr. Lee and his co-conspirators are wearing. We have them fleeing the state together, which is indicative of consciousness of guilt, and we have them returning to the state together and then resisting arrest, which they completely overlooked, holding up and creating an hours-long standoff with police, during which time he and his co-conspirators destroy evidence, including his phone is destroyed, and hide firearms, consistent with what was used in the course of these crimes. There's obviously a lot more, but I don't want to belabor the point that this is far beyond mere evidence or mere presence. Our obligation is only to establish a reasonable inference at this stage that he was committed to the crime, and I would submit to the court that we could present this grand jury transcript to a jury and get a conviction beyond a reasonable doubt as to the defendant right now. So we've clearly met that burden. The attempt murder ground raised in Section 2, obviously this court has dealt with before, so I won't belabor that point unless you have any questions.
Final word, Mr. Hendron.
And Your Honor, with regards to bringing up the clerical error issue, this has been actually the first time that I've had that opportunity, waiting for all the transcripts to come to light. So that's why it was brought up. And when we speak about the superseding indictment itself, though, again, there would have to be something that the grand jury presumably had to look at, acknowledge that Mr. Lee was charged with these counts 13 through 22, which obviously, at the very least, one of them is a kidnapping where substantial bodily harm results with victim over 6, the allegation. These have serious consequences to them. So the one thought is, we're trying to go through the grand jury's minds, which I can't do. I don't have the ability to have them canvassed or questioned. But if that impacted them going forward when they deliberated the superseding indictments that came along, second superseding and the third superseding. And the same thing would go with regards to implicit bias is only going to take place through the state canvassing the grand jurors. I don't have that opportunity because of it being in that secretive process. So that's why there are certain things that come into play that place the onus on the state to inquire, making sure that there's no bias that takes place when they deliberate and if they ultimately elect to return a true bill. Thank you.
Okay. Regarding the first ground, I do find that I deny on that. I find that the state did present enough evidence to sustain an indictment. The surveillance video of the home invasion was presented, as well as the surveillance video, defendant traveling with other co-defendants. There was a participation in a standoff, other circumstantial evidence that was presented and detailed by the state that was sufficient to meet that slight or marginal evidence standard. Regarding the attempt murder count, the state did present slight or marginal evidence to get to that, to keep that count alive, and then issues of malice will be for the jury to decide. Regarding counts 3 and 4, I'm going to decline to say that bias of the grand juror would not be appropriate in a writ, but here we have just a suggestion of the potential for bias without any actual presentation of bias. It's a bare and naked allegation. It's denied based on that. I do concede that there is an unusual procedural history as to count 3, but there's nothing beyond that. And then count 4, I don't even know that there was really any pretrial coverage of this before, but at any rate, the bias isn't fleshed out as they previously ruled. And then finally, I don't think that the fifth matter or the final matter regarding discovery is cognizable in this petition. And so I will decline any relief on that ground. Overall, the writ is denied. Thank you.